My lord, my lord, may I have your lordships kindly, my lord, to mention, my lord, this application along with the main rate, my lord, was taken up by your lordships on the 9th of January, my lord. Thereafter, my lord has directed that the matter appears on the 20th of February. On that day, my lords were pleased to sit in court number 20, and I mentioned the matter, but it's still not there in the list, my lord. Great.
My lord, may I have my lord's leave to mention one matter, my lord? My lord, this is a matter in relation to the Rose Valley writ petitions. My lord, I had already mentioned this matter, but it is not appearing with the matter that has been listed today.
We'll see. Let the Rose Valley appear there. Call it.
After the petition, Lordship, I am appealing for the Lordship on the last occasion. Lordship asked that how many cases has been taken up by CBI, whether 76 as per our record, as per state.
My lord, the dichotomy has been sorted. My lord, 5 was still with since charge sheet has been submitted, it was not handed over to the CBI. And my lord, so far as
Have you been shown arrested in those cases?
Yes.
Is he in bail or
Which 5 cases?
only one. Baki sector? কনফার্ম করতে পারছেন
কোন কাজটা একটু
এই 5টা বলছে ধুবুলিয়ায় বেলে নেই বাট আদার্স আনশিওর দিস আর দি 5 কেসেস
so what we are serving these 5 cases which you claim was with CBI have been sorted out.
Yes.
And they are with the state.
Yes.
So you would be at liberty to produce the accused physically or through electronic. All right.
Now, Lord,
And you can pay for bail.
in one case, Lord, since my friend has said, in Hulia case, but the record is unable. We are unable to get it. But the record,
That's it.
not even in the court.
No, it has been traced. It has been traced.
So we just keep it
Pick
at
up.
that. And we ask the state to furnish the report. State will furnish report on the case. In respect of the other cases, and wherever you are in custody, they will produce you
Madam.
virtual.
Madam.
Nowadays, Lord, there is a notification by the correctional home that the under trial prisoners need not be Lord, produced to Lord.
That is what we are saying. If state shall submit report on the adjourned date.
Lord, may I say one thing? They have referred the 215 cases were at Balurga.
Yes.
But there, Lord, we have been shown arrest and Lord, we have been paid for bail. Bail has been granted. Lord, in all cases, Lord, the bonds has been given, Lord, which will go beyond Lord 1 lakh.
That you make a prayer. We cannot,
and we are also unable, since there is an order passed by these honorees.
When the report comes, you also make a prayer. How many cases your bonds are of this nature? We will direct the magistrate to reduce the bond or consolidate the bond.
Mine.
Also a Supreme Court decision on this. So bring that.
Another thing, Lord, we are also facing trouble. And also, Lord, some of the cases, Lord, there is an order passed in this proceeding
No.
where all the cases, Lord, DCGM, DCMM 2 of Kolkata, Lord, has been made as designated. But wherever the records are there, Lord, all records has been transmitted to this court, and this is in transit. Lord, some cases, Lord, we are also unable to furnish more.
Immediate to
My Lord,
next
2 weeks, Lord.
4 weeks.
4 weeks. Great.
Number 3, please, one. Well, the learned tribunal has remanded the matter back and provided a new lease of life. Well, when the same was not contemplated under the Act, my lord, the order, it was heard by your lordship, my lord, page 83.
Lordship, the tribunal remanded the matter. Lordship said that we will explain the last sentence that within next 2 months or 3 months, whatever your lordship deemed fit, to complete the de novo adjudication order.
But there is
That
no
was your lordship's view.
But no period was contemplated under the Act. I am agreed by the last line only. But so far the remand is concerned, my lord, my primary objection is on the last line, my lord. Having a fresh period of disposal, there is no period of disposal contemplated under the Act, subject to correction by your lordship.
Yes, the confirmation was. This is an applicant confirmation.
Most obliged, my lord.
Now the confirmation was done by the 31st of March.
But that was set aside by the learned appellate court.
Correct. So if it is set aside, naturally it has to be reheard and a decision taken on the confirmation. The setting aside is not on merits, it's on
Audio alteram partem, my lord.
on
Right.
procedural infractions.
Right, my lord.
So the tribunal would definitely have the power to remand for a fresh hearing and decision.
Perfect, my lord. So far that part is concerned, my lord, I am not genuinely aggrieved. I am agreed by the last line, which provides that there will be having a fresh period of disposal of the matter before it. So, my lord, there is no period of disposal contemplated under the Act. Altogether, my lord, it's 180 days only.
Correct.
And 30 days, my lord, within 30 days, complaint to be filed, then 180 days.
Our thing is, the provisional attachment was made when? The
I just,
Provisional attachment,
attachment was on 23/9/22.
correct.
please, my lord.
No.
My lord, 31st March
March
2022, order was on 23rd of September 2022.
That is within 180 days.
That was within 180 days.
So this will be heard and disposed of within 15 days.
My lord
Only
asked me to take instruction whether within 2 months adjudicating authority can complete the proceeding. I have to answer on that. My lord, what I suggest, instead of 2 months, if your lordship can grant him 3 months time.
but that will be beyond the period of 180 days.
How can it be that within 7 days you'll do it, right?
But only difficult.
No. Let
Well,
us calculate 180 days. According to you, there cannot be beyond 180 days.
Well,
Correct?
so far the attachment is concerned. So far the disposal is concerned, my lord, there is no
The
time period, my lord.
attachment itself,
For the confirmation, I am sorry, my lord, it's
the
not attachment, the
confirmation
confirmation.
is 180 days.
Right, my lord.
So the 180 days run from the date on which the demand takes place. Because this is a fresh consideration.
My lord, subject to correction, 180 days runs from the date of attachment, my lord.
Correct, because but then here it's a remand.
Right, my lord.
And the remand will give a fresh lease of life for 180 days from the date of remand.
My lord, subject to correction by your lordship, my lord, there is no lease of life contemplated. So far the adjudication is concerned. My lord, may I just, my lord? So far the adjudication is concerned, there is no lease of life. So your lordship will add limitation, my lord, or some period, my lord, which has never been contemplated under the Act.
We
Well,
can.
my lord, had there been any period provided under the Act, my lord?
The confirmation itself is provided.
My lord, it's if not confirmed, then 180 days, my lord, it's other way around, my lord. It has to be confirmed.
So it
If
has-
not confirmed, then 180
So
days.
decision is to be taken within 180 days. Now, if the decision is taken and it is found that there is breach of procedural fairness, not something which is on the point of merit, but on procedural fairness, and the appellate court remands, it can always remand by giving a timeline within which the disposal is going to take place.
No, my lord, only your lordships will kindly appreciate, my lord. My lord, so far this timeline is concerned that it's in reverse
Let us
direction.
see the
My lord, kindly see, my lord, I had placed this earlier, my lord, this Kausalya infrastructure, my lord, which said, my lord, that timeline cannot be extended in other way, that, my lord, the adjudication will go on. But it's 180 days is, my lord, after that it has to terminate, my lord, the attachment will terminate, but the proceeding can go on. So far, matlab, the continuance of the process.
What is he going to confirm if the attachment?
But that risk, matlab, kindly appreciate, matlab, he cannot take benefit out of his own wrong. Matlab, at the end of the day,
Where
there
is
is
the
violation of audio alteram partem.
Where is the wrong?
So,
But it's the very basis, matlab,
correct, that is why he has remanded it.
matlab, kindly sees this, matlab. The adjudication proceeding can go on, but matlab, the attachment cannot survive after 180 days.
Yes.
You check. Just give me that act. I have to copy it. There. It will be अच्छा था PMN no part of it.
But first of all, 180 days is not.
It's valid in section 5, not in 8.
that you such a
Please, my lord.
come to 8.3.
Right, my lord.
What is the final order this procedure entails? Please read out where the adjudicating
Authority decides under subsection 2 that any property
shall
money
by
laundering.
an order confirm the attachment of the property made under subsection.
Right, my lord.
Or
Retention of
property
17 or
among
18 months,
granted
not
to
yet.
and shall continue till the end of the other proceedings. This is all that the adjudicating authority can do. Now, if by your argument, since there is a breach of principles of natural justice, the confirmation which was done in the
Adjudicating authority.
adjudicating authority's aid is stated, and the matter is again wanted for reconsideration. How can we hold that the provisional attachment order will expire because of loss of time? The reason being as follows. A, the provisional attachment order merges into the final attachment and continues and no longer continues once the final order is passed. Now, the final order of attachment having been set aside, the provisional attachment again revives and will continue for such period as prescribed under the law. That is the maximum that we consider from your end. Correct? Let us say 180 days. The confirmation was done on the 170th day. You may argue that even if you remand beyond 10 days, it could not have been. And since 10 days have lapsed, there is nothing to be remanded, because what we are saying is, if there is no provisional order of attachment, then what is the adjudicating?
It will be an act in futility, my lord,
It will
according to
become an activity. We would like you to address us on this. Otherwise, it becomes useless. And we cannot interpret the law in a manner where the power itself, what you may, I don't know whether you will argue or not, it may be a very adventurous argument that once set aside, there cannot be any remand. Now, if that we perhaps may not agree. Now, if you want to make good that point, please place authorities that there is no power of remand in the appellate authority.
No, only what is troubling me, my lord,
Now,
if I may
the
reflect
powers of
my
the
mind,
appellate authority?
my lord, please kindly comes to my lord.
Section 25.
35.
35, my lord.
35.
It is a tribunal which is constituted
Appellate
under.
tribunal, that is
Right.
what we are saying, that is section 25. And powers will be procedural.
But 35 is the
35.
procedure and power.
It is deemed to be a civil court.
Yes.
While trying a suit. So a civil court trying a suit in respect of summoning from a
Well, 26 subsection 4 may be relevant.
Please show.
Section 26 subsection 4. On receipt of an appeal under subsection 1 or subsection 2, the appellate tribunal may, after giving the parties to the appeal an opportunity of being heard, pass such order thereon as it thinks fit, confirming, modifying, or setting aside the order appealed.
Wide powers.
Hello, what is troubling me, if I may just reflect my mind, my lord, kindly appreciate, my lord, today an order is passed. On one, my lord, an attachment takes place. On 180th day, my lord, it is attached and there is a violation of natural justice. I go to tribunal, my lord, tribunal remands the matter back. Then again a fresh lease of life they get. Second time again, my lord, there is some procedural violation, my lord, committed by them. Again, I come to the appellate court. So in this way, my lord,
That's the wisdom of the tribunal, sir. That is the wisdom of the tribunal.
well, only what is happening, my lord, then the lease of life, which was given for, my lord, survival of an order, not for adjudication, my lord, that gets
Yes,
renewed every time.
Adjudication of what?
But adjudication, well, according to
It's
coastal law,
something
both are
like
different.
Something like this. There's an appeal against an interim order of limited duration. Right. Now the order of limited duration expires accordingly. When it was confirmed and the court in revision is passing is considering the question of remand, what will happen? That is the
Right,
that
my
is
lord.
the
That's the
argument
issue.
that you are making. The here what has happened is what the adjudicating authority was seeing is the confirmation of the order and not the provisional order. So once the provisional order is confirmed, the confirmed order has no time frame. Therefore, reconsideration of the confirmation of the order will not be guided by the time frame of the provisional application order. You
Absolutely.
understand? So that has no impact when the appellate tribunal is not considering a challenge from the provisional order. It is considering a challenge from the confirmed order. Confirmed order, until and unless specified, will continue till the end
Disposal of the
proceeding.
case.
And therefore, there was it was completely within the jurisdiction of the appellate court.
And here the confirmed order was set aside, my lord. Confirmed order was set aside.
Not set aside, it was remanded for fresh consideration. And there,
Then, my lord, the provisional order triggers up, my lord, again.
it may trigger up and will continue for such time which will be prescribed by the appellate authority, because it is not deciding the longevity of the provisional order. Your judgment and argument are based on a challenge to the provisional order.
Right, my lord.
If the challenge was to the provisional order, your argument is well taken. But if the challenge is to the confirmed order, which does not yield to a timeline, the remand also will not yield to any timeline.
But only difficulty is that, my lord, the moment the appeal is allowed, that means partially allowed, my lord, with a remand. There may not means like, my lord, the order is not acquitted.
The provisional order will be deemed to continue till the decision is taken, because the challenge is not to the provisional order and the provisional order no longer exists. What is being decided is the legality of the final order.
But when the final order dies with setting aside, in that case, my lord, no order is there.
If it was set aside simpliciter, you are right. If it is a setting aside with a remand, the adjudication continues, and there the deeming provision comes in that the adjudication for confirmation will continue.
Well, kindly appreciate one situation, my lord. Suppose against an order of conviction where accused persons face the trial being outside, being on bail. The order is set aside, matter is remanded back. But then they will go back to their earlier position, my lord, they will be on bail. So here also, my lord, once the order is set aside, it goes back to the provisional order, my lord. Then issue is that every time, my lord, there will be revival of time, my lord, and which will be against me.
You are again misdirecting yourself, because you are regulating an adjudication on the basis of a final order. An adjudication on the basis of the final order has got nothing to do. Challenge to the provisional order, yes. What happened in the Supreme? The provisional attachment was challenged, and during the subsistence of the challenge, it expired. The adjudication was going on. It said that the adjudication will go on.
But my lord, the bottom line is same, my lord. If that is, if the order never survives, then, my lord, what would act will be in futility.
Read paragraph 2 of the judgment.
Please, my lord. According to the petitioner, the High Court, having acceded to the argument of the petitioner that the provisional attachment order served on the petitioner did not disclose proper reason, much less tangible reason, and only reproduce the provisions of the Act, ought not to have relegated the petitioner before the concerned authority for the recording of reasons. It is further argued that the provisional attachment order triggers the adjudication proceeding, and as the provisional attachment order is set aside by the High Court, no adjudication proceeding can continue further against the petitioner. Going by the scheme of Section 5 and 8 of the PMLA, we have no hesitation in observing that the aforesaid argument is misplaced. The fact that the petitioner has succeeded before the High Court does not per se result in nullifying the adjudication proceeding, which nevertheless can proceed and can be taken to its logical end by the adjudicating authority in accordance with law. The satisfaction to be recorded by the authority, then it's on other issue, my lord. But
No.
Section 4 is there, my lord. Sorry, my lord. Paragraph 4 says so that adjudication proceeding, if any, that can continue despite there being no provisional order.
For what?
But that's paragraph 4.
That is paragraph 4 in relation to that. Tell us what the adjudicating authority will do.
Malad, that may, in a given case, malad, suppose the
Tell
properties
us
are
what-
otherwise attached, my lord, then they can definitely.
Tell us what the adjudicating authority will do.
Malad,
If the provisional order is set aside, what will the adjudicating authority do? Confirm what?
malad, but that's
Tell
the, malad, that's the
All
order.
right, we'll keep it for next Thursday.
Please, malad, please. I'll try to
Please
assist you, lord.
satisfy us that powers as deemed fit and proper will include remand. Because specifically remand is not.
Not there.
I will show.
So the power of remand in a tribunal will be there if it has the power to set aside an order, please.
Most of them.
Yes,
Malad, next
What?
Thursday then, malad.
next Thursday.
Malad has recorded
Any
any order?
urgency in the next matter, anything?
Your lordship recorded any order?
Mr. Mitro, for
Lordship, as far as the ADC is concerned, certain directions were required.
My lord, in this matter, my lord, I have an
Lordship, as far
application,
as-
my lord, for addition of party can 11. Kindly, my lord, allow me
we
to
will
be.
sit on another day.
Lordship, may we just file the report? There is an audit report for Chocolate Hotels Private.
Next day we'll file.
Lordship, we needed one direction in the meantime. Lordship, what has happened is, although the auditors have been appointed and they're auditing the accounts, what has happened is, since the company directors and the shareholders are not there, it is not a statutory auditor as per the Companies Act. So we needed some direction from your lordship so that the auditors can act in terms of it and complete. Although they have done for 17 and 18, this is only merely an audit, but not a statutory audit.
The auditors are, what is there to direct? You have already commenced the audit.
Lordship, the audit is there, but the difficulty is, as per the report, your lordship, they are not doing the audit because they are saying that we are not backed by the shareholders. There is no AGM. Our appointment of an auditor has to be communicated to the ROC. This has also not been done. Because of this, they are not being able to do.
This needs to be heard out. I'm opposing, that's my application. This needs to be heard out. It needs to be circulated for the lordship. Here the-
Lordship, very well. Will kindly allow me to file 17 and 18.
One of the report. But I he has proposed to transfer share.
Lordship, this.
That they cannot. But I am also operating. It is not. We will consider it.
Lordship, in the meantime, then may I file the audit report and circulate it?
Please, whatever audit you can do. Don't take any proactive action with regard to changing of the shareholding,
Very well.
etc. of the company.
Very well.
Right? Because the thing is, the ADC run the company in usual course of its business, not to do a change of shareholding, etc. of the
No, Lordship, it is not for change of shareholding. It is only that the directors who were appointing the auditors, they do not have the qualifying shares. So I believe there was an attempt to give them the qualifying shares, nothing beyond that.
That is so, we will direct that the audit is being done pursuant to the.
Lordship, that will
directives of
solve the
company.
problem. Lordship, that will solve the problem.
Right. We clarify, heard Mr. Ford for ADC. we clarify that the audit is done at at the direction of this court. Bas.
Your Lordship, a report file.
All other documents will be circulated, placed on record on the next day. All right?
Your Lordship, a report
Additional
file.
party have an application.
My lord,
Your Lordship,
Can 11? Can 11 have?
Please give them with the numbers.
It is already fine.
Coming up on another day.
Your Lordship, may I file a report by enforcement?
We will select a day and that will be a better thing to decide now rather than let it come up.
Not yet filed the report.
Let it be placed. Let us look into them. Then we'll give you an opportunity to file your. Then you file it.
I applied for
Yes,
the
let us say when should we give these matters?
Your
I
Lordship,
applied for the Provident Fund Authority, my lord.
Very good.
Your
Make
Lordship,
your submissions on the next day. Tell us which is the.
May I give my affidavit of service, my lord? I have already served, my lord.
That's wonderful. But we are not verifying, neither am I looking as to who are the persons who have been served and represented. We need to look into that exercise. All your names are recorded, all your submissions recorded.
Your Lordship, may I file the report by Enforcement Directorate?
Yes?
May I file the report by Enforcement Directorate, Your Lordship?
What?
Enforcement Directorate, Your Lordship.
Fine.
Lordship.
Who are you? Wait, all these things will come later on.
Lordship.
That's true. We are not giving you liberty to file it today.
my lord, on the earlier direction, there was a direction upon me to file affidavits. My lord,
Don't you understand? Today we are not taking all these papers. We're just fixing a date. Tell us which date is convenient to all of you.
any day, my lord, any Thursday, my lord, or any other day.
Okay, Daco. Today on the
Where was fixed?
one session, there is an officer entrusted for this. Maybe keep this on 13.
My lord, 13th, my lord, I am led by the board.
Mr. Bose has difficulty.
Some difficulty. I have also some.
So we, Mr. Bose, 13 what we do is, you see the glamour of the submission of documents. We'll do the submission of documents on 13th and then if we need your vice counsel, we will put it on another. As of now, 13th.
I have some personal difficulty. Only one day. Only one day I have.
Yes, so sorry, 13th is the beginning of a long weekend. Then, sir, 20th is already we have got the other Troya group of matters. So we can give you the next date is 27th. 27th of March. All right. So Mr. Nilopush is okay.
Yes, my lord. Before closing of accounts.
Lordship, just one more indulgence. Lordship, as far as the AD is concerned, the nominee of Enforcement Directorate has changed. May the ADC be reconstituted accordingly in the new nominee? Yes, my lord.
We are informed that the nominee at that ED's nominee has been altered. The ADC shall be reconstituted as follows. Please give the particulars. Please accordingly reconstitute. Please give the names.
Just the names.
Just the name of the ED. Because we don't have to set out the other names.
Yes, my lord.
Only the name. Yes. The other assigned matter that NPS plenary. Anyone in the assignment?
My lord, I appear for my lord. I think my learned friend is 14.
We are adjourning this for the day. Huh? come up again.
Can it be taken up after 27 because all this
Adjourn 4 weeks.
4 weeks?
But
Great.
this matter, my lord,
নামটা বলে দাদা নামটা দাদা
issue
15
অজয় লুলা
Correct. You will hear it after 4 weeks.
Four weeks, my lord, that will be.
Next,
15 minute and
we are saying.
15 is a matter relating to 15 is a matter relating to Angel group of company, my lord, and one man committee is sitting about the matter, and also the some monthly list, March. Yes.
Monthly list of March 17.
17, my lord, I am appearing on behalf of the petitioner, my lord. This is the affidavit of service. Here, my lord, last week I mentioned this matter, my lord. The property is being sold by the company, my lord. This is a sole proprietorship concern. So, my lord, some precedent way.
I am referring for number 8. Who is arguing
Yes, he is one of the director.
One of the other directors
Not appear, but no, my lord.
fresh notice to non-appearing respondents, monthly list of March.
item 97
18.
The urgency that is under the affairs of the under the control of the ED. Property belong to Saroda Really. Was taken over by the ED pursuant to your attachment order. Thereafter, your worship, ED has not been taking care of this for the last 1 year.
Well, it can be tagged with that main matter, Abdul Khalek Lashkar, that main Sharoda matter.
Where is the council?
Your Lordship, Mr. Firoz Idilji is leading me in this matter.
Yes.
Your Lordship, he's at his legs in another.
So we are keeping this matter on 13.
Your Lordship, the can was served upon us today only, Your Lordship. On today only at 2:29 p.m. we have been served.
13. We are keeping it on 13.
Your Lordship.
13. 13.
With 17, item number 17. Respect of item number 17, the item number 90 is also the same company, Freedom, in the monthly list. 90 of the monthly list, my lord.